A landmark ruling in the Bisho High Court, that's in the Eastern Cape, has ordered that a victim of medical negligence be provided with free medical care instead of paying him off with a lump sum of money. Well, the court ruling has overturned the common practice of paying out lump sums for medical negligence cases against the state. To understand the impact of the judgment, let's speak now to the Department of Health in the Eastern Cape Province, and the head of department there is Dr. Rolene Wagner. Dr. Wagner, thank you very much for your time. Let's get your understanding of this court ruling and what you think the impact on your department is going to be.
Thank you. Good morning, Chloe, to you and to your viewers. Thank you for the opportunity to have this discussion with you. This judgment is really of strategic significance to our department. As you were saying earlier, up until this judgment, common law only allowed us to make settlements as lump sum, what they call once and for all payments. Also, at the same time, in terms of our accounting practices, we're not allowed to budget for those. And so as the numbers of claims escalated and the value of those claims increased significantly year on year from around 2013-14 onwards, we had an increasing debt that we were incurring because we were taking money from our healthcare services to pay these medico-legal settlements. Over time, as at the end, just to illustrate the point, in the financial year 2020-2021, we paid out 921 million rands worth of settlements just up to that point. Cumulatively paid out around 3.5 billion rand. And you can well imagine that 3.5 billion rand was coming out of our operational budget of around 7.5 billion rand for goods and services.
Based on...
So there was
Sorry, Doc. So sorry to cut in. And based on your observation, I mean, these are massive numbers you're talking about. 921 million rand, and I imagine this would cover a particular financial year. But cumulatively, as you say, 3.5 billion in medical negligence claims. Who mostly benefited from these? Because there has been unscrupulous lawyers.
So I'm careful how I word it, because obviously not all lawyers who defend these claimants, the plaintiffs, are unscrupulous. However, we have investigated claims that have been made. Our Provincial Treasury Forensic Auditing Unit has investigated all claims that have been paid out. They've identified three possible areas. The first category are possible fraudulent claims. The second category is where there's been overbilling or overreach in the claims, because we find in the Eastern Cape the claims against us are significantly higher than claims in other provinces. And the third area is trust fund irregularities. So we've had instances where A, the trust funds were not set up. B, they were set up but significantly delayed in having them set up. C, we transferred funds to the attorneys, but the funds had still not been transferred to the beneficiaries. And the contingency rules normally allow up to a 25% deduction on a claim for the legal fees, and when you're looking at 25% of a 30 million claim, it's a significant amount that comes out of that claim that goes towards legal fees that is no longer available for the child's future medical care. Of course, the other challenge that you have is if lawyers are not transferring the funding, the question is where are those funds going to, and does the child benefit? In those instances, we are working with law enforcement agencies as well as the Legal Practice Council. We've actually handed over, thus far, we've assessed 221 trust funds. We have submitted allegations of misconduct to the Legal Practices Council, around 25 of those. 15 have already been referred for disciplinary hearings, and there are 10 that are under investigation. Those legal firms have asked for more time to provide evidence and to defend themselves. So yes, it is that the funding allocated may not always go to the beneficiaries, and then they become dependent on us anyway further down the line.
Dr. Wagner, talk to us about an instance where the victim of medical negligence is not a child, but an adult who perhaps was a breadwinner, bringing a certain amount of money home, in order for the family to be looked after. What happens in a scenario like that where the person says, yes, I'm happy with free medical health care, but I cannot work anymore, so I need the money?
Yeah. So in this particular judgment, this judgment is evidence of about 80 to 85% of all claims tend to be those by mothers of children or parents of children with cerebral palsy, but there are a few other cases that are not maternity related. In those instances, the common law in this case that was applied allowed you to have heads of damages. And please, my disclaimer up front is that I'm not a legal guru or I have no legal qualification. But my understanding is that you are allowed to, in this judgment as an example, it includes future loss of earnings. And so within the lump sum amount, the plaintiff made a case for why they believe that a certain amount should go towards loss of earnings. And as the defendants, we then could counter that or provide alternative arguments until we arrive at an amount that we agree upon. In this instance, the claim is 34.5 million rand. Of that 34.5 million, the court agreed on funding that would go towards a vehicle so that the child can attend all treatments that is required or collect supplies that was required. It covered any adaptations to the home that is necessary because of the disability. It also covered future loss of earnings.
Yeah.
And of course, the accountants and the smart finance guys calculate, they use actuarial studies to predict what the likelihood would have been of the earnings and the loss of those earnings.
Sure. And just how much protection does this judgment provide your department with, particularly around those, and you rightfully said that not all lawyers are unscrupulous, but there are those who have made it a gainful employment of sorts to defraud the department in this way. So how protective a measure is this now for your department?
When one reads the judgment, you'll notice that the judge was very careful to make sure that the Bill of Rights and the rights of the child are protected in him exercising that judgment. He also talks about risk protection, which is concerned to both the plaintiff and the defendant. And that the judgment allows that the child will receive reasonable care for the duration of that time. And so we have proven, it was part of the case for us to prove that we can provide reasonable care at our facilities. I'm so sorry, there are messages coming in as I'm having issue. My apologies.
No problem.
We have provided evidence that clearly we are able to provide reasonable care and that there are schedules that we've submitted. In those schedules, we indicate our capability to provide medical care, as well as schedules about the supplies that will be provided to that child. Some of these are required monthly, some care is required daily, some are provided annually or depending on the lifetime of the supply. A bed, for example, it would be replaced every 5 to 10 years as agreed between the parties. So the judge has made every effort to make sure that by receiving care, he is receiving reasonable care and that his rights are protected. If there are any variations later on, further down the line, we are now providing care as and when needed, rather than paying them up front, not knowing what is actually coming further down the line. So I think there's a good balance in ensuring, yes, there's the lump sum towards the critical expenditure. However, the child is protected in that the money now goes into the trust fund. The trust then administers the fund as required. But what is also new is each public and private sector appoints a case manager. Those case managers meet annually to agree on the needs of the child in the year ahead because we've made an undertaking to pay. So the new judgment allows for services that we will provide, supplies that we will provide, but also the undertaking to provide for any services that we agree the child needs, but that we do not provide.
Yeah.
And we obviously budgets to cover that as well.
This judgment, as we said right at the beginning of this conversation, Dr. Wagner, it's a landmark judgment. But who is it targeted at? And I'm talking here in terms of the institutions. Is it public health care institutions or is it all-encompassing? I'm talking about private health care.
Again, we would need the interpretation from the legal gurus to confirm, but my understanding is that this case, because the judge has established common law, anyone who's defending such a case can draw on this case. We don't have, as the public sector, because we're the defendant, we don't have to go and prove that we can, in fact, provide care in this manner. And the judge talks about the public health defense. So logically, one would assume that this applies to all cases in the public sector in the Eastern Cape. However, I'm sure it will be referenced by even the private sector in that common law has been established. We've proven the case as the public sector. I'm not sure if the private sector would need to prove the case themselves, but certainly they will draw on the mechanism of payment as a reference point.
Sure. Final question to you, and let's talk about tightening measures. In a way, this particular judgment has helped you to try and save money by spending wisely, but also, I suppose, setting perimeters for what's allowed and what is not. How are you planning to tighten measures from here on, assisted by this judgment?
Thank you. Well, we have an integrated medico-legal strategy. That strategy has got a number of different facets to it. The first facet was obviously we needed to stop the loss of funds. We called it the hemorrhaging of funds through this lump sum settlements, medico-legal settlements. In the last 2 financial years, had we not mounted this defense and had we not been granted this judgment now, we would have lost another 2 billion rand out of our funding envelopes. And that's a significant impact on our ability to provide care. Ironically, as you lose money, you're actually decreasing our ability to provide good quality care. So that was a very important strategy. The second strategic objective that we've done is to coordinate our legal defense. Unfortunately, one of the cases that we've joined the Western Cape Department of Health in is against an attorney whom we're aiming to have disbarred. It cannot be normal practice that a single firm can have cases to the value of 500 million rand before the courts decided within 3 years. And so it also points to our capability to defend our cases, the claims against us. And so the Specialized Litigation Unit of the Office of the Premier works together with the Department of Health, our legal team, and we've also appointed a firm of attorneys to assist us in the medico-legal defense. The third component is just how we administer the claims, and so we are rolling out an electronic patient record system. Many of the claims come from as far back as 2004, 2014, 2015. Those records are not always available. At that time, litigation and medical negligence was not that big an issue in our sector. And so the records tend to be recording what is found and not necessarily recording the absence of critical signs that can help you defend yourself in a negligence case. And so it has been difficult to defend ourselves in these instances. But now with the electronic patient record system that we're rolling out, with the administration that we're putting in with IHEA as well, this strengthens our capability to have a control over the system. But ultimately, the way to prevent medical negligence is to improve the quality of care that we're providing. We have a number of interventions. During COVID, we had a bit of a setback as a department because COVID impacted maternal mortality. However, post-COVID, we've been putting our programs back in place. And it starts with preventing unwanted pregnancies by making sure that you are able to give teenagers and women appropriate contraception to prevent unwanted pregnancies. Our teenagers are at big risk because they're likely to have complications and have unsafe deliveries. And then, of course, it comes to strengthening the capability to do cesarean sections, to manage the antenatal care, and to manage the delivery and postpartum. We have identified factors that are beyond our department. They are what we call patient-related factors. And so we've strengthened and already started working with communities, NGOs, to increase awareness that if you are planning pregnancy, that planned pregnancy you need to book for your antenatal visits and you need to go regularly so we can identify risk early on in the pregnancy. We can then appropriate centers. And of course we've strengthened, we've not just looked at making sure that it's safe for moms and babies, but we're also looking at improving quality of the rehabilitation services that we provide, but also improving our surgical and orthopedic capability in the province. Those are just some measures.
Dr. Wagner, let me take full advantage, therefore, of the fact that I'm talking to a head of department in a province of the Eastern Cape that has had many of these cases of medical negligence. And let me ask you a general question now. Given the stigma that is associated with public health institutions, a person, I'm simply talking now language in the streets, where someone says, I went into a hospital with a headache and I went out with an arm amputated. That's just anecdote, right? I want to ask a question of you that says, how would you describe the general state of healthcare institutions, public healthcare institutions in the Eastern Cape?
Oh, thank you for the question. I can understand that citizens have had concerns. Often the stories that make it into the media are the negative stories, even your story about your anecdotes. And so that tends to paint a very bleak picture. However, I must also say that there are millions of other patients that we help every single year. In the primary healthcare sector, as an example, we see around 3.5 to 4 million patients in our clinics. And whilst there are complaints that we do receive, it's not as many as the number of patients that actually receive good quality care. And it's just unfortunate that we don't always share those good stories, and it's important that we do share those good stories. I cannot ever guarantee that we don't have problems. So obviously we do have problems, but I can say that we are systematically improving the quality of care that we provide. And we do that in partnership with our clinic committees, our board, our hospital boards. It's important for us to know and understand what is important to the people we serve and make sure that we provide the best and safest care possible. I can also say that many of our, because often there's a comparison made between us and the private sector. And I do want to remind us of the fact that even private sector doctors and health professionals are trained in the public sector. We are accredited to provide really good quality training, and we produce excellent healthcare professionals. These are people in our services that provide care on a day-to-day basis. Not only do we have one of the most highly qualified people, but we've made significant investment into machinery and equipment. Just this year alone, we've invested 67 million rands in machinery and equipment just for the care of mothers and children in our province. Never mind the investment in our diagnostic capabilities, etc. So we are not perfect yet, and I think that there's always room for improvement, but it can't be argued that we're not, on a year-to-year basis, slowly but surely improving the quality of care that we provide.
Dr. Rolene Wagner is the head of department, the health department in the Eastern Cape province. Thank you very much for your time, and quite an interesting court case or court outcome coming out of the Bisho High Court, and we shall see how this helps the health institution there in the Eastern Cape, an institution that says it has lost a lot of money. You have heard. She says 3.5 billion rand cumulatively is the amount of money that that department has lost through claims of medical negligence, and some of those, of course, she says, is because some lawyers would have inflated these figures. So this court case, in a way, goes some distance to try and help stop the wastage, if you like.